Ladies and gentlemen, welcome back. Let us now move on to our discussion on topic 2, response to COVID-19 from the legal and technology communities. Please allow me to introduce the moderator for this session, Mr. Nick Chan, Vice Chairman of Belt and Road Committee and InnoTech Committee of the Law Society of Hong Kong, and Vice Chairman of the Legal Committee of Hong Kong General Chamber of Commerce. Mr. Chan, please.
Thank you, Corinne. Good afternoon or good morning, depending where you are. Thank you for joining. It's my pleasure to be moderating this session, topic 2, response to COVID-19 from the legal and technology community. To my left, we have the Honorable Justice Russell Coleman, who is the judge of the High Court of Hong Kong. And there's no better person to ask than Justice Coleman on how we are in terms of the judicial response to COVID-19. Over to you, Russell. Thank you.
Yes, well, hello to you wherever you are, and whatever time of day it is, wherever you are. I think there can be no doubt, if I were to say by way of introduction, that COVID-19 has jolted activity and increase the pace of the use of technology in the courts here in Hong Kong. And let me grasp immediately a nettle to stop Nick having to ask me later. And that is that there is a perception that perhaps Hong Kong was a little slower than some other jurisdictions to grasp the use of technology to conduct hearings on a virtual or remote basis, at least to start with. I think that is in part true, and it is largely explained by the fact that in Hong Kong we have been lucky enough not to have a full lockdown in the way in which some other jurisdictions have had, so that unlike other jurisdictions, judges like me have been able to attend our courts and be physically present in courts. And of course, in a geographically small area like Hong Kong, the travel problems that have plagued other jurisdictions have been of less impact here. So after some perhaps initial hesitation, also because of some concern that there needed to be proper rules, perhaps even primary and subsidiary legislation to deal with remote hearings, I think it can be said that the Hong Kong courts kicked into gear. And during a period that we call the GAP, which stands for the General Adjournment Period, which took effect from the very end of January until about the end of April, when most courts were not physically sitting, we did get into technological gear. For myself, I was due to start a relatively long commercial matter, and it occurred to me that it would be appropriate at least to have a telephones direction hearing to plan for the various possibilities as to when that trial might start. And I therefore took the opportunity to write a judgment explaining why I thought that it was perfectly proper for the courts in Hong Kong to have, for that case, telephone hearings, but probably even video hearings, as a proper use of the existing rules and mechanisms available for at least civil litigation in Hong Kong. And I wrote the judgment to explain why. It was a case in which all of the participants, including myself and the two main advocates and the solicitors, were familiar with arbitral process, where telephone directions hearings are, of course, relatively routine. And such a hearing went ahead. It was useful. There were no glitches technologically, and the trial indeed followed fairly shortly thereafter. Then there followed a decision of the Court of Appeal in Hong Kong, which extended, I would say with some enthusiasm, the situation to video hearings. And indeed, one might think that a video hearing is even better than an audio or telephone hearing. And they set out the basis upon which the Court of Appeal thought that it was perfectly proper under the existing rules with the available mechanisms to conduct civil litigation at first instance and on appeals using remote hearings. And there have been a number of cases emphasizing the two important points of fairness and openness that have led to such hearings taking place at first instance. in the appeal courts, including in our final appellate court, the Court of Final Appeal here in Hong Kong. I'll come back to that in just a moment. We've also now got a significant number of hearings being conducted by masters dealing with the interlocutory procedural aspects of High Court work on telephone hearings. And there have, of course, been naturally a larger number of cases involving witnesses who ordinarily would travel to give evidence physically in a courtroom in Hong Kong, who have either been unwilling to travel or are simply unable to travel to Hong Kong, and their evidence in greater numbers has been taken using video conferencing facilities. The question, I think, will arise as to where advocates may need to be in future cases, and potentially even judges, although that, of course, gives rise to jurisdictional questions. The Court of Final Appeal has conducted final appeal hearings with one of the judges appearing remotely, either from Australia or from England, but physically appearing on a screen in the Hong Kong courtroom. And I think the view is that appellate courts with more than one judge can take place without any difficulty in that way. It may be different if there's only one judge who would, I think for jurisdiction reasons, need to be in Hong Kong. And as I say, it's a small place. We can usually physically get to our own courts and sit in our own courts. Well, where next? The court's bought much more equipment. It's extending the use of VCF. It's updating the various forms of technology and the software. The idea is that ultimately anybody will be able to use the appropriate link to the courts for free without any particularly special equipment other than the use of a desktop or a laptop, using the technology that will be provided by the court, and over which the court wishes to maintain, understandably, the degree of control that ensures safety and security for the participants and for the discussions. And I think it's recognized that though prompted by COVID, there will be a continuation of such hearings in future in any event. Civil litigation is what I've really spoken about for the moment. Of course, the situation is different for criminal cases. There's been much less of the ability to take up the use of technology in criminal cases. And indeed, there is a drafting process putting in place, it is hoped, the appropriate legislative amendments that will facilitate that and make it clear also for civil cases how remote hearings can properly be conducted. General points I would make on these are that each case requires individual consideration as to what is the appropriate method of hearing. Is it an entirely remote hearing, an entirely physically present hearing, or some sort of hybrid hearing? That requires earlier case management and earlier thought, earlier preparation by the parties and indeed by the court. If I want to offer you some further thoughts, I think VCF hearings must continue to bear the main trappings of a court hearing, particularly if the court is physically sitting, the judge is physically sitting in his or her own courtroom. It's not always possible, perhaps, in all circumstances that we can foresee, but for the moment in Hong Kong, at least the judge is likely to be physically present in court. It may be that there'll be some public and media press access to the court at the same time, because I think it is a feature almost universally understood from those jurisdictions conducting remote hearings that although you gain something by seeing the head and shoulders of the participants, and every little inflection, every time I blink, I see myself blink now, you're doing the same, but what you're missing out is the bigger picture of the body language and the way in which other people are reacting to each other as you see it in a physical courtroom. So some physical presence, at least to see the judge in action, is an appropriate thing, as well as providing the openness and therefore the transparency with which we're all so familiar and which is such an important part of the way in which we do business in our courts in Hong Kong. It's also been my experience at the moment that our existing VCF setup does tend to provide camera angles which are less than ideal. I took evidence this morning using a VCF from a witness who was physically in Taiwan. I was looking at a screen where he was on my left, but the camera was filming me from my right. So every time I looked at him, I appeared to be turning away from him, and something to which we all need to give some thought. And I think particularly with our new court buildings that are coming in Hong Kong in the next few years, real thought is now already being given to the way in which those courts are going to be set up for that purpose. How participants are being able to see each other, whether they're grouped on screens next to each other in their teams. Of course, it also is a different process. There's necessarily less interruption from a busybody judge like me, you might think is a good thing. And indeed, frequently, if one doesn't interrupt at some point, then one doesn't need to interrupt on the same point later on because the ground is already going to be covered. So I think in conclusion, it is necessary to ensure that all of the elements that we expect from the judicial process will continue. Rest assured that the Hong Kong judiciary is looking careful at these things. There are a number of judges who are pushing it along with the assistance of some very active and able members of the judiciary administration. And we can therefore all focus on this in the long term, irrespective of COVID, but as the waves seem to come and go, it may be that we will be doing it in waves ourselves. We tied in, of course, to the other aspects of technology, which are also being fast forwarded, such as the use of e-bundles, not far away, I think e-filing, and that sort of thing. So that's our approach in the judiciary to the technology that we can now use to conduct hearings remotely or partly remotely for making sure that the business of the courts really does continue, notwithstanding any external difficulties. Thank you, Neil.
Thank you, Justice Coleman. Very humble man. He will be remembered for championing the change, the remote hearing. First case was heard by you, wasn't it? Right. Thank you, Justice Coleman. I'd like to welcome Dr. George Lam, Chairman of Cyberport, who is here with us today. Thank you. I'd like to now first go live to Privacy Commissioner, Ms. Ada Chung, who is joining us remotely. Hello, Ada.
Hello. Can you hear me, Nick?
Yes, loud and clear. Over to you. Thank you very much, Ada.
Thank you, Nick.
Thank you.
And thanks for having me here. I would like to share with you some of the work of my office in response to COVID-19 and also technological developments. I think all of you would agree with me that the pandemic accelerates the use of technology in our lives. And while technology facilitates the normal functioning of the society, I think the advancement of technology also carries inherent personal data privacy risks. And I would say that it is important to strike a reasonable balance between the protection of privacy on the one hand and the pursuit of legitimate interests, such as interests to protect public health or the resumption of normal business activities on the other hand. Like many other jurisdictions, the Hong Kong government has adopted a variety of technological measures to combat COVID-19, including the Stay Home Safe mobile app, which is used to monitor compliance with quarantine orders, an online dashboard, which is used to disseminate information to alert the public of the geographical location of COVID-19 confirmed cases, and more recently, the Leave Home Safe mobile app, which was just launched last week to facilitate contact tracing. Actually, my office has provided our input whenever necessary to the government in the design and development of all these apps. In particular, I would like to point out that unlike some other countries like Singapore or France, which stores all the data obtained from the contact tracing app in a centralized database, the Leave Home Safe app adopts a less privacy intrusive approach by having all the data collected by the app stored in the user's mobile phones and in an encrypted form. It is only when the user is diagnosed of COVID-19 that the user will be directed to upload all his records to the health authorities to facilitate further investigation. And in some countries, like for example, India, Bahrain, and Kuwait, they have incorporated real-time GPS tracking data into their contact tracing apps to increase the accuracy. However, in Hong Kong, we noticed that no GPS location data is collected by the Leave Home Safe app, and data will only be collected when the users scan the QR codes at the relevant venues. And it is all voluntary up to this particular moment. I noticed that over the weekend, there have been talks about whether this scheme will be made mandatory, and we will have to wait and see. At the international level, my office has conducted a survey among different data protection authorities in the summer to gauge the international community's response to COVID-19 in the areas of, for example, contact tracing and location tracking, and the sharing of data, in particular health data, with the health authorities and law enforcement agencies. And we have compiled a compendium of best practices, and this compendium is now available on our website. It is interesting to note, for example, that most of the jurisdictions, actually 72% of them covered by the survey, have used contact tracing apps. And the use of the apps are mostly voluntary. Quite to the contrary, the vast majority of the jurisdictions, about 75%, did not use location tracking as a measure to combat COVID-19, apparently because of the privacy concerns in the various jurisdictions. And in terms of legislative backing, in some jurisdictions, laws were introduced to back up contact tracing. And it is interesting to note that different jurisdictions may make different approaches to either address privacy concerns or to address the protection of public health. And in some jurisdictions, for example, Australia, laws were introduced to limit the use of data collected by the contact tracing apps. However, in some other jurisdictions, such as Bulgaria, laws were introduced to facilitate the use of data in contact tracing and also in enforcing quarantine orders. So you will see that different approaches were taken in different countries, apparently because of the different concerns on privacy issues and also probably because to address the imminent public health concerns. Back to the work of our office, I would mention that in response to the pandemic or the new normal, my office has issued several guidance notes in the past few months to provide guidance to employers, employees, and also schools on the collection, processing, and the retention of personal data, in particular sensitive health data. And we are working on several new guidance notes to provide more comprehensive guidance to employers and employees under the work from home arrangements. And we target to issue all these new guidance notes by the end of this week. Incidentally, on biometric data, given the more common use of biometric data nowadays, we have updated our guidance note on the collection and use of biometric data. Some highlights of the more important principles and recommended measures include, for example, to assess the necessity and the proportionality when you consider to use biometric data and opt for the less privacy intrusive alternative if possible. Conduct privacy impact assessment to identify privacy risks and incorporate appropriate mitigating measures in the design of the system. Enhance transparency in the data processing activities, such as by explaining the use of biometric data, why the use of biometric data is necessary, and that there are sufficient data security measures are in place. And you should also provide individuals with informed choices whenever biometric data is to be collected. And as all other data, we should always ensure the minimum amount of data is collected, that the data collected is accurate and also secure. And with that, I have come to the end of my presentation, and I think I've used up all my 8 minutes.
Thank you, Privacy Commissioner. So you see this is the app you talked about, happily using it. Leave home safe. Okay, thank you. Well, I'd like to now go to Dr. George Lam. He's a man of vision and also good in execution. Over to you, Dr. Lam.
Thank you, Nick. Good afternoon, ladies and gentlemen. I spent just a few minutes to quickly cover perspectives from the tech side. As you know, the pandemic has affected every sector, including the legal profession. It is happening everywhere. For example, in banking, we have to now adopt e-banking and increasingly e-KYC and all the digital solutions, to deal with the pandemic. And in the education sector, learn from home, e-school, EdTech applications are really very popular now, actually a must rather than a nice to have. And then the list is long. So, but I like to say that despite COVID-19, we see some bright spots. One is that digital transformation has not just accelerated, but has gone mainstream. And this is good for Hong Kong and the whole region as well. And this is a good foundation for dealing with the so-called post-COVID-19 new normal. I'm not sure whether I can say post-COVID-19 now, because we are still in the middle of fighting it. But I think looking forward, digital is the way to go. It's a given, including a legal profession. So I'm very excited to quickly mention a little bit about Hong Kong's global tech hub, Cyberport, which now hosts 1,600 tech companies and startups. It is really the department store for LawTech, RegTech, among other things. It is also the FinTech hub for Hong Kong. And FinTech is a good example. Banking and finance, or financial services, has been a traditional sector in the economy, but it has adopted FinTech solutions increasingly. And now with the COVID-19 pandemic, FinTech is now the way to go. So in Hong Kong, Cyberport is also the department store for FinTech solutions, among other things. So EdTech, MedTech, you name it, we are going digital in a big way, and we have no choice. And the remaining few minutes, I'd like to just quickly go through some examples of how LawTech and RegTech can help. Several application areas. One is client communications. As you know, virtual meetings are now the mainstream solution. So we need to adopt very efficient, reliable work management platforms with authentication, data backup functions, and advanced communication features to ensure productivity. At Cyberport, we have a number of startups doing just that. Very exciting startups, including LegalX. get on the web and see it. You'll find that it's very exciting. Many clients, are looking for, very reliable solutions with also instant messaging. But to make sure that it's really safe, and the firm, for example, can actually retrieve conversations, past conversations for compliance purposes, and to ensure full data ownership, for example, you need to have the right digital solutions. There are two startups I'd like to mention to you. If you have time, look at something called Leap Expert and Team Note. Fascinating startups. Another area I'd like to share with you is about documents management. We lawyers are, dealing with not just words, but documents is a fact of life. We need digital systems, and we need systems that can provide efficient reviews and edits, and also traceability, and so that everything can be tracked, for audit trail, to facilitate negotiation, as well as document e-signing, not physical signing. We cannot go to Guangzhou, for example. We cannot go to Kazakhstan, but we can do e-signing. Now, that is fascinating because such digital systems, can be found now also from Cyberport. I give you one example, and remember this startup called Zigo. Take a look and you'll find it fascinating. Translation is another thing, important thing about document management. You need to actually find tools that can be smart enough, and with some AI power as well, because you want accurate and you want, reliable translation. In Cyberport, you can find a startup such as a startup called Translate FX. This is also amazing. Among a few other startups, offering different things, you can find all the translation solutions for now, and more will come. Another area of opportunity is search for all the precedents, and it's a tedious process, and a lot of possibilities for errors, human errors. But now with artificial intelligence, natural language processing, or this is another buzzword, NLP technology, you can really, deal with a lot of searching, a lot of, analysis, and this will make your claims, for example, more backed up with more supporting precedents. One startup that you should look at is LIM technology, L-I-M. Very interesting. The list is long, but I think in the interest of time, I give you one example. Another is a cybersecurity area. This is important, particularly for sensitive documents. You want to avoid potential data leaks, hacking, and other cyber attacks. And you need to cover, and log all the monitoring or the auto blocking, and you deal with threat scanning, behavioral analysis, trend detection, and more. Look at this startup called Securely. Fascinating. And LawTech, amazing. Another hot area, we're talking about how to apply artificial intelligence, machine learning, data analytics, and blockchain, etc., to facilitate handling of compliance requirements such as KYC, AML, transaction monitoring. With such solutions, we can ensure early detection of suspicious transactions, for example, to avoid heavy penalties, for example, later on. And the business community relies heavily on legal advisors and compliance officers adopting RegTech solutions, so that they can deal with increasingly complex regulatory requirements. Another area of opportunity is really this opportunity to export legal services with technology. Now we're talking about the Greater Bay Area. We're talking about Southeast Asia, with the recent signing of the RCEP agreement, Belt and Road Initiative opportunities. Dispute resolution is one area where digital tech can help, and with eBram doing such a tremendous work, and with Nick, and Thomas, Dr. Thomas So, and team doing good work. I mean, that's one good example of, and one of the first steps, important steps that we can take in this direction. And then we have a lot more opportunity in deal making, a lot of cross-border M&A, cross-border transactions. All of these need digital solutions because we cannot fly, we cannot meet face-to-face. We need to do it digitally, and we can do it with similar or even better quality and better backing of security and all the other value-added features. In closing, I'd like to say, we also need to use digital technology to do LawTech, RegTech, to embrace the upcoming era of digital assets. The whole world has gone digital. We are entering the digital economy era, and we need to deal with that with technology. We have done well in Hong Kong with FinTech. We can do the same with LawTech. In Hong Kong, to do FinTech well, you need Fin and Tech. To do LawTech well, we need Law and Tech. We have both. We can do it. Finally, advance warm welcome to Cyberport, the department store for LawTech and RegTech. Thank you.
Thank you, Dr. Lam. I'm sure all of us are looking forward to queuing up to do a shopping spree, but are cooperating, with our friends at Cyberport. Well, let's go to Dr. Thomas So, JP, our past president of the Law Society and still chairman of our Belt and Road Committee. Dr. Thomas So will join us by a pre-recorded video. Dr. So.
Good afternoon, ladies and gentlemen. Thank you, Nick, for giving me the opportunity here today. And thank you, Law Society, for organizing this webinar for me to share our experience with you all relating to the use of technology in dispute resolution that we are operating through a platform run by eBram. Now, many people ask about eBram. So before I go on to talk about the services that we provide, I will give 2 minutes, a very short time to do a brief introduction of who we are. Now, about eBram, we have a vision which is to facilitate Hong Kong to become an international law tech center and a deal-making center, as well as a dispute resolution and avoidance center. We are supported by a few organizations, the Law Society, the Bar, the Asia Academy of International Law, as well as a high-tech company, logistic and supply chain, a multi-tech R&D center. So that is a combination of legal knowledge and technology knowledge. Now, let's talk about the COVID-19 online dispute resolution scheme. This is a scheme that we rolled out at the end of June this year with a view to responding to the market demand generated by the impact of COVID-19, as a result of which there are disputes that would require speedy and reasonable price dispute resolution services. The objectives of this scheme is to provide speedy and cost-effective resolution of disputes which are caused by the COVID-19 pandemic. And this is specifically designed for helping micro, small, and medium-sized enterprises, because the market survey reveals that many of the MSMEs are reluctant to pay high legal fees and services fees for dispute resolution services. And that is the reason why we came up with this scheme, hoping to be able to provide a speedy and cost-effective solution to MSMEs. What type of disputes can you submit to the scheme? First, it must be a dispute that is COVID-19 related and that the amount is not to exceed $500,000 Hong Kong dollar, and that one of the parties to the dispute must be a Hong Kong resident or a Hong Kong company so as to enjoy this scheme. This scheme entails a one-stop shop service in which we would assist, first of all, the parties to try and negotiate for settlement, failing which we would assist in appointing a mediator to provide mediation services, hoping to achieve a settlement, and failing which we would help appoint an arbitrator to help to arbitrate the dispute. The intention is to provide the whole one-stop shop service roughly within 6 weeks timeline, in that we would allow 3 days to do the negotiation, 3 days to do the mediation, and roughly a month to 10 days, a month and 10 days to conclude the arbitration part of the procedure. Now, all in all, although this one-stop shop service involves negotiation, mediation, arbitration, appointment of mediator, and appointment of arbitrator, but because we are funded by the government in this scheme, each party is only required to pay Hong Kong dollar 200 registration fee, then you'll be able to enjoy the whole process. Now, the strength of this scheme, obviously low cost is one, and is very user-friendly in terms of the use of technology, and that the whole process is tailor-made for dispute generated or resulted from a COVID-19 pandemic. We have a number of case managers standing by to assist in managing the flow of the dispute, and we have flexible timing so as to enable parties not to require them to be physically present in order to attend mediation session or arbitration hearing. We also allow cross-border dispute, because as long as one party is Hong Kong based, Hong Kong resident or Hong Kong company, you would be entitled to use this services. And EBRAM is also one of the arbitration center acknowledged to be entitled when the arbitral award is made to use the interim measures that has been agreed upon based on an arrangement between the Hong Kong government and the mainland government. So all in all, access of justice is real. In terms of the progress and milestone about this scheme, this is a dedicated platform, and we already have recruited over 150 trained mediators and arbitrators who are on our panel to help to deal with cases coming in through this scheme. We have also enhanced cybersecurity measures to ensure very strict data privacy compliance, and we have also rolled out relevant marketing and engagement activities and are now receiving cases and numerous inquiries. We have also been collaborating because this is very much a community-based project. So we have signed MOU with a number of community organizations, including the Asian Academy of International Law, the China Maritime Arbitration Center, Consumer Council, HKIC, and many others who are very supportive to our scheme. We also are involved in capacity building. As you have just heard, we have trained 150 plus mediators and arbitrators. They all need to be trained in order to know how to use our online platform. We will continue to do that. Not only the dispute resolver, but also this creates a lot of opportunities for young lawyers and IT practitioners who would like to see what we call a crossover before legal practice and technology practice, which is now called LawTech. And this also reinforced the Hong Kong long-standing status as a dispute resolution hub, and we hope to take the cross-border and international dispute resolution services to the next level. About our ODR platform, quite apart from the scheme, there are a few features that I would like to take this opportunity to take this through with you. First is that as I said earlier, this is a very user-friendly technology in that you can use your handphone, you can use your computer just to log in and download the ODR, the online dispute resolution agreement. You could sign it online, you could pay your fees online, you could select your mediator out of 5 that we normally pick for you to choose. You can select that online. This video conference platform is self-designed specifically for mediation use, in that we be able to hold a multi-parties conference whilst at the same time servicing the need when we have a joint conference where we could have 3 parties, and then at any time we could switch it to a caucus session where we could turn one party into another room and allow the mediator to have a conference direct with another party while keeping the other party away from the conversation. The platform is all self-hosted in that, as I mentioned earlier, we pay very important consideration to security and data protection. They are all kept in Hong Kong. The cloud is hosted in Hong Kong, and we continue to upgrade our development and investment in that area. About our roadmap, what we can offer today, I have already talked about, so I don't want to repeat that. But going forward, we're going to have to roll out a few other very important technology products, which we think would help to take us to another level. Finally, we welcome you all to come and visit us. Our headquarters is in Justice Place, and our branch office is in Cyberport. Thank you again for listening to me, and I hope that eBRAM will be of interest to you and would be of and that we would be of use to you in assisting you with your case. Thank you.
Well, thank you very much, Dr. So. Without further ado, let's go to our friend Raphael Tay, who is a member of Law Asia. Thank you, Executive Committee member of Law Asia. Thank you, Mr. Tay. Over to you.
Thank you very much, Nick. Fellow panelists, Judge, a very good afternoon. It's a real pleasure to be here to address this particular conference, the Belt and Road Conference. Heard the rest of the 4 other speakers, so that's been quite helpful. Judge, I just want to say that I really enjoyed your presentation, and it's good to know that just the wheels of justice turn in spite and despite of the pandemic. I'm going to share my screen. Okay. Right, the topic is digitalization and transformation of businesses in response to COVID-19, a legal perspective. Having on hindsight, it's probably better to have stated a lawyer's perspective. What is digital transformation? I think one of the biggest shocks that has happened in this last 10 months, since World War II perhaps even, is that the global pandemic that has affected all of us, irrespective of which nation or which country we are from, has led to multiple lockdowns and a slump in consumer spending, which of course then led in turn to the labor market implosion, in which I think the economists of the 8th of October suggested an equivalent of nearly 500 million full-time jobs disappeared, literally overnight. The COVID-19 pandemic is the ultimate catalyst, I feel, for the digital transformation, and will greatly accelerate because of several major trends. I think it is quite clear to just say that this pandemic is not just something that we have experienced the last couple of months, but I think it will have a lasting effect, both socially, emotionally, in many of our societies. The way we work, for example, will change. For us as lawyers, as people with stakeholders of the law, we are aware that the wheels of justice must turn. So in order for that to happen, lots of different methods and methodologies and technologies has been deployed in order to ensure that hearings, applications, and trials continue to take place. Now, the pandemic itself will also have a very lasting effect, not only on our economy and how we go about our daily lives. People talk about the new norm. People talk about a new normal. For some time, I used to think that was just mere platitudes. But actually, increasingly, I'm beginning to be convinced that really there is a new norm and things will not be the same post-COVID-19 pandemic. So it's not likely that we will return to pre-pandemic norms. While this pandemic itself has forced many businesses to reduce or to suspend operations affecting their bottom line, it has helped to accelerate the development of several emerging technologies. Now, this is especially true for innovations that reduce human-to-human contact, automate processes, and increase productivity amid social distancing. Now, I've identified 5 different technologies that would probably transform the way we work. The first one is the artificial intelligence. Now, artificial intelligence, a number of technical innovations, such as intelligent data processing, face and speech recognition, have become possible because of AI. Now, consumer behaviors won't go back to pre-pandemic norms. Consumers increasingly will purchase more and more goods and services online, increasing the number of people working remotely. AI will also be particularly useful for those in the retail and supply chain industries through machine learning and advanced data analytics. AI will help those companies detect new purchasing patterns, trends among consumers, and deliver a greater personalized experience to online consumers. AI tools will also analyze large amounts of data to learn underlying patterns, enabling computer systems to make decisions, predict human behavior, and recognize images and human speech, among other things. You will probably also find in due course that AI-enabled systems also continuously learn and adapt, and therefore in itself is a very, very productive productivity tool. Now, cloud computing. I think cloud computing, before COVID-19 pandemic happened, there were a lot of people that were not very comfortable with cloud computing. If they had any doubts as to the robustness and the security of cloud computing, I guess it is fortunate that cloud companies are weathering this pandemic stress test caused by the sudden spike in workloads and waves of new inexperienced users well. In fact, Microsoft has just reported that it had a 775%, yes, you heard it correctly, 775% spike in cloud services demand as a result of COVID-19. Cloud computing or cloud technology is not just it's not just about storage of data, but it is primarily useful as a technology because it's scalable, it's for scalable usage. You'll be surprised that your Netflix, your Siri, Alexa, Google Assistant, for example, Skype, WhatsApp, amongst others, Microsoft Office 365, all use cloud computing technologies. I mentioned about backup and recovery usage of cloud. Google Drive, Dropbox uses that. Facebook, LinkedIn, and Twitter, amongst the social networking applications that we all normally use, are also hosted in the clouds. Now, the third one is the virtual reality and augmented reality. Again here, this pandemic increased the number of people using VR headsets to play video games. But for a long time, we used to think that it was only good for games. But increasingly, you will see that developers are exploring virtual travel destinations, and dare I say, in conferences and seminars and forums such as these.
Rafael, sorry, 1 minute.
Thank you.
Thank you.
So basically, you'll probably find that we will have VR conferencing in due course. Now, 5G networks, again, that's very important. It's much more important than many of us have thought. And people now have realized the need for faster data sharing and increased connectivity speeds will accelerate the rollout of 5G, notwithstanding whatever geopolitical issues that we may have. Finally, the last technology, the Internet of Things. Again here, you'll find that the IoT of things, which is a network of physical objects using sensors, software, and other technologies will be on the rise. And you'll see an exponential growth in this area. What are drivers? What is driving this? Obviously, it's technological growth and innovation, which is something that has been there. But more importantly, COVID-19 has done a reset to our lives. People want or desire a healthier life, to live better, to be healthier because of COVID-19. And of course, the response from businesses to COVID-19 has also driven this transformation.
Can I invite you to show your next slide as well? Because
yes, okay.
I'm so sorry.
All right. Because more so than the interest in sovereign governments or states and geopolitical factors. Now, these are some of the issues which I want to highlight, but data privacy, cybersecurity has been spoken of, but I really want to talk about human rights. Human rights, you will see the fundamental differences insofar as human rights response to COVID-19, as well as the technological advances that are going to take place. You'll find that perhaps Western ideological or philosophies will be less in terms of willing to embrace some of these technologies because it's an infringement of individual rights, and quite rightly so as well. But a lot of the Confucian-centered states along the Belt and Road may not be so concerned about these things. So what you'll find that as a result of this pandemic, as well as the technological advances, you'll find that human rights becomes a very fundamental issue because different societies, different communities will take a different stand from this. Thank you very much.
Thank you very much for joining us from Malaysia. Thank you all. So we have some good questions from our about 500 attendees today. Thank you very much. First question is to Justice Coleman. Hong Kong into conducting e-hearings, witness cross-examined?
Yes, I think I mentioned that earlier. Definitely that's happening more often simply because people are unable or unwilling to travel. And it's throwing up a number of issues. As I say, it all depends on early detailed individual preparation per case and indeed per witness. The technical details of establishing the relevant video links, including pre-testing, having the effective necessary wording of oath or affirmation in the relevant religious book, identifying who else is in the room, perhaps an idea if there's a degree of mistrust between the parties about whether there needs to be two cameras, one looking at the witness and one showing the rest of the room. Where the documents are they always in sight? If it's an e-bundle, how do we know what the witness is looking at? And the ability, of course, to show the witness the relevant documents at the same time as everyone else is looking at them, including potentially any additional or new documents that crop up. I think you'll find that individual judges in different types of case are building their own standard forms of directions for this, many of which directions are going to be common across the cases. And you'll see that only increasing.
Thank you, Justice Coleman. Question for our commissioner, privacy commissioner. Do you think the laws should be updated to give you more teeth? I know you're smiling, showing your teeth, but should the law be updated to show more teeth? Unmute yourself.
Certainly, Nick. I do think that the laws should be updated to enhance our investigation and prosecution powers, especially to deal with offenses such as doxing. Because from our experience since around the middle of last year, we received a huge number of complaints and unprecedented level of complaints relating to doxing cases. And we found that very active. And we have to collaborate with a number of other law enforcement agencies in order to enforce the law. So if we are given more powers to enforce the law, I do believe that enforcement would be more efficient and that would be beneficial to the victims.
Thank you very much. And a question for Dr. Lam. How much money would you put on the table at the Cyberport to help, law firms or start LawTech?
Well, great question. I wish I have more opportunities to interact with the 500 participants. A few things. One is, when Cyberport started this fintech cluster, it was about 50 companies, 50 startups, but now 600 in the whole of Hong Kong. And in Cyberport alone is 400, so we have 2/3. And then when we started our esports cluster, digital entertainment cluster last year, it was about 50, And I mean, it can grow now over 100. And we are holding the second digital entertainment leadership forum this next month, December 11 and 12. Please come because there's a lot of media law and also IP issues at play. And then for LawTech now, we have anywhere like 50 to 100 excellent seed capital to start. I can see Hong Kong hosting the largest and most vibrant and credible LawTech and LawTech cluster in the whole of Asia. I was very pleased to hear from the judiciary, from Mr. Justice here, about all the good work and really tech savvy and progressive, more so than the lay community can expect. I think with this teamwork, I mean, the judiciary, the legal profession, law society, and the business sector, and the young entrepreneurs, I think we can do a lot more. And at Cyberport now, we have the Cyberport Macro Fund that can co-invest, with a lot of experienced tech investors in promising LawTech and RegTech startups. And we are very excited with digital dispute resolution and with digital asset trading, digital assets business. Hong Kong
we'll look you up and call Cyberport home.
Sure.
A question for Mr. Tay. You are enduring a lockdown, aren't you, in Malaysia?
Yes,
how's it affecting your business as a lawyer? And how are you overcoming it? A quick tip for us before we go for, Karine to make more announcements.
Well, Nick, I'm not quite sure whether we can give you any tips, but I can tell you can share some of our our experiences. I think as lawyers, like in Hong Kong, the judiciary has taken a very proactive role. So we are doing a lot of our applications online now so it's in a virtual platform. The only thing we have not gone to do is to have full trials, because exactly some of the issues that Judge just mentioned, because we felt that that was probably not conducive for the time being. I think Hong Kong has set a different standard in trying to do that, but Malaysia has stopped short of applications for all hearings. But I think in terms of businesses, I think it's important to see that as lawyers, we have to upskill ourselves, because there's a lot of issues that no textbook, no law school has taught us about. So I think it's something that we need to play a proactive role. Thank you.
Thank you. Please all join me to give a big hand to our great panelists. Thank you very much, and thank you for listening in. Thank you. Over to Kareem. Thank you.
Thank you, our moderator, Mr. Chan. Also, our speakers, the Honorable Mr. Justice Coleman, Ms. Ada Chong, Dr. George Lam, Dr. Thomas So, and Mr. Raphael Tay. So now, thank you very much again for your valuable insights, which have certainly inspired us very much. May I now invite Mr. Chan, the session moderator, to present a souvenir to our speakers as a token of appreciation for their contribution and to take a group photo. And may I also invite the Honorable Mr. Justice Coleman and Dr. Lam to accept the souvenir on behalf of all the speakers.
Very happy to do so. Thank you. Thank you. Thank you. Thank you all. Thank you.
Thank you. And this brings us to a close of this discussion on topic 2. We will now have another 10-minute break before we move on to the next session. So see you again soon. Hello, this is Kareem Wong again to welcome you back to this last but not least session of today's webinar on topic 3, reforming corporate rescue law under COVID-19. May I now introduce you to the moderator of this session, Ms. Gillian Doe, member of Standing Committee on Company Law Reform of Companies Registry of the Government of the Hong Kong Special Administrative Region, and member of the Belt and Road Committee of the Law Society of Hong Kong. Ms. Doe, please.
Thank you, Kareem. Good afternoon, everybody, and welcome to the last session, the topic 3 of this afternoon. It's my pleasure to be here and host this topic 3 about corporate rescues. This year, we've seen unprecedented happenings, and nothing can compare to COVID-19. It's affected so many businesses, employers, employees, and the business community has really taken a severe hit. How do different countries react to this and deal with this? Deal with businesses which are going through hard times? Is it possible to have a legal environment which helps you through hard times while you're trying to stand on your feet again, and come back when times are more stable and prosperous? So today we are very delighted and very honored to have our guest speakers and to discuss with us a framework, their respective framework within which struggling businesses can operate, and how it impacts in their particular locality, and how the community is reacting to this really unique situation and challenging times. So today we're very happy to have with us our esteemed speakers. We have Carol Denniston, who's a partner at Squire Patton Boggs in San Francisco, who's an experienced restructuring lawyer. Carol has been working in the distressed municipal sector since 2009 and has represented many districts and stakeholders in restructuring engagements in the US. We have Constantine Dobrynin, and I just want to take this opportunity to wish Constantine a happy birthday. We were told by our friends in Russia that you are celebrating your, your 18th birthday today. So congratulations. So it's very happy to have you with us, and thank you for sharing your time. So Konstantin is State Secretary and Deputy President of the Russian Federal Bar Association and Senior Partner of Pen and Paper Attorneys at Law. You specialize in criminal and criminal procedural law and constitutional law, and you are a member of the Federation Council of the Russian Federal Assembly and Deputy Chair of the Federation Council Committee for Constitution, Legislation, and State Construction. As well, we have David Green. Hi, David. President of the Law Society of England and Wales, and Council Member for International Practice, and was Chair on the International Committee and the Policy and Regulatory Affairs Committee. David is Senior Partner at Edwin Coie and is the Head of Litigation and Dispute Resolution Group and the Group Action Litigation Department. And last but not least, we have our official receiver, Phyllis McKenna. Hi, Phyllis. Phyllis joined the Hong Kong government in 1988, and prior to her appointment, she held the position of Assistant Director Legal in the Lands Department, and she's been our official receiver since February 2017. So thank you so much, everybody, for being here this evening. And we're going to start off with Carol telling us a little bit about the U.S. approach to insolvency, how there's been federal aid to businesses and changes in your bankruptcy code, and what can we expect in the Biden administration. So over to you, Carol.
First of all, thank you so much for the opportunity to speak with you today. I appreciate that, and I have to say I've enjoyed everything I've listened to. We are kind of in a strange place in the United States. As everybody knows, we have Chapter 11, which is our mechanism for restructuring distressed debtors. We also have a Chapter 7, which is used for liquidation. And right now, the bankruptcy community is quite concerned about the need to make adjustments to the way we handle Chapter 11. For the first few months of COVID, we saw judges basically putting cases in what we call the deep freeze. For several months, the case was stagnant and just sat there. And some of those cases have come on through the reorganization process, others not so much. And recently we've begun to see a number of articles calling for bankruptcy reform, recognizing that come next year, we're likely to be hit with a staggering number of Chapter 11s as well as Chapter 7s. And the Chapter 7 piece has been a part of what has impacted most of our small and mid-sized businesses. Since the pandemic started, these businesses have not had the liquidity to restructure, and they've gone straight to Chapter 7 liquidation, which causes huge concern in terms of what's going to happen when we return to our new normal, because we will have lost a huge chunk of the business community. And that's because there wasn't any other option for those businesses. Many of them were family businesses. Many of them were in the restaurant sector or the personal services sector. And so the bankruptcy code, in terms of providing the only realistic option for them to liquidate, wasn't particularly helpful, and I think is ultimately going to hurt the economy if we don't figure out something else to do. The Chapter 11 situation, as I said, many of the cases have been put into deep freeze, but we're facing an oncoming problem. As any of you know, we go through the restructuring process. It's very expensive, and to the extent companies are able to avoid Chapter 11 and reach agreements with their creditors outside of the need for a formal bankruptcy case, they do so. We have seen an increase of pre-packaged or pre-negotiated bankruptcies, which also reduce the cost to the extent that the debtor is able to reach agreement with its creditors, both its secured lenders and in many cases, a substantial number of unsecured lenders. The trade creditors learn of these cases once they're filed, and there's an opportunity to go through an expedited process on a pre-negotiated or pre-packaged bankruptcy. But those options are only available for the large companies that are able to access debtor in possession financing and able to use the tools that are options for them under our code, but expensive options. And the thing that has come out recently that is concerning everybody is our process turns on being able to confirm a bankruptcy plan. And that has been called into question because the need for liquidity to exit bankruptcy, you have to pay a certain number of your creditors, particularly those that lent you money for debtor in possession financing. You have to pay your administrative creditors, those that continue to provide you with goods and services during the bankruptcy in order to exit. And those are sometimes hurdles that are insurmountable if there's the market is not liquid, the credit is not good, or in what we expect to see more of, the debtor's unable to come up with realistic projections on the business's future performance that will allow it to exit bankruptcy and provide some kind of stable return to its creditors. The issue that is troubling to most of us that are in the field is that because of the virus, a significant number of business leases are going to be empty. And we're going to see the people that were operating in those leases filing bankruptcy. And we also expect to see a number of landlords filing bankruptcy. To give you an example of the concern, it's the fact that there's no way to get to evaluation. The best example is a shopping center, because most of those tenants have either gone into bankruptcy or are struggling themselves. Their businesses have been closed down because of various orders, depending on what state they're in. The lockdown orders have pretty much gutted the ability to do business in many of the stores that are in a shopping center. And shopping centers that file for bankruptcy have almost no way to see into the future as to what their new revenue stream is going to look like, how many tenants will return, how many leases they'll be able to sign, how much they'll be able to charge. So to get a shopping center out of Chapter 11 is going to be a challenging thing. So the discussion to answer the question that we started with was, what's the Biden administration going to do? Well, the Biden administration, we expect, based on comments that have come out since the election, and I guess in some form or fashion leading up to the election, Elizabeth Warren, who you may recognize as a name as someone that was a contender for president for a period of time, has for years argued that we need significant reforms to Chapter 7 for individual creditors, that we need to be taking care of our individuals. And she has a program that we think that the Biden administration will pay some attention to in terms of trying to make Chapter 7 easier for individual debtors. As for Chapter 11, we have many people calling for changes to Chapter 11 to do three things: to make it cheaper, which means you need to make it faster and more efficient, but also to make it less complicated. And to try to expedite for those middle market businesses that wouldn't ordinarily be able to afford a Chapter 11, to make Chapter 11 more affordable by taking out many of the things that are needed for the larger businesses. And by looking at options there for the middle market, we can begin to hopefully preserve some of the value that would be lost if they end up in a Chapter 7. So the discussion amongst the professionals, while we don't have anything formal and nothing's been presented to the administration, the discussion is that we need to simplify this and come up with some kind of mechanism to reduce the cost, reduce the time, and take some of the requirements out that aren't needed for small businesses so that they can operate in an 11, reorganize, and then exit with something of the business left. And part of the challenge here is that anytime you end up in a Chapter 11, your equity is wiped out unless the equity decides to contribute new money. And we're in a situation in the economy where it's not realistic to expect the owners to be able to finance a case and contribute. So I think that the takeaway to wind up here is that we need some changes or additions to our bankruptcy code in the US to address the challenges we're going to face next year. Because cases are going to take longer, so they need to be cheaper and more efficient. And we need to think long and hard about how we're going to handle the valuation proposition, because typically to get out, you have to be able to show that you're an alive operating business. And if you can't do that, you can't get out, you end up converted, you end up sold to a third party, or your case gets dismissed. Some combination of those three things. None of them are good for the economy, and obviously none of them are good for the owners. So we need to come up with a process that's more flexible and responsive to the situation that our middle market is finding itself in. So we have a lot of work to do.
Thank you so much, Carol. That's probably a summary, or I suppose, of all the problems that everyone is experiencing worldwide. I want to ask Constantine, how are things in your location? How are people dealing with this difficulty in liquidity, in the time and cost it takes to try and restructure a business, to keep it going when you're trying to get more money, issues like valuation? What is the framework like that allows people to continue to operate in these challenging times in Russia? So I'll turn it over to you, Constantine.
Hello, my dear. As a State Secretary of Russian Bar and as a normal, I'm very glad to virtually greet you at this friendly legal event. You know, I'd like just to make a very brief, maybe to add some important and hope interesting point about how the situation is in Russia, especially after the first year of world COVID war. So first of all, Russian law literally doesn't have corporate rescue law either. Four main insolvency procedures: it's supervision, financial restructuring, external management, and liquidation. Two procedures focus on restoration. It's financial restructuring and external management, rarely used in Russian insolvency court practice. None of them provide effective tools to recover financial status, preserve assets, and carry on business. Most insolvency procedures end with liquidation and termination of business. Only way to rescue business, it is settlement agreement. During this COVID-19, you know, the situation with law, with legislation, it was, I could compare it with invasion or crackdown, which definitely perplexed our normal life and our legal world. Because, for instance, first months of fighting with pandemic were very erratic. And I mean, not only medical measures, I mean legal measures, which were undertaken by all governments, not only by Russian government. Some measures were incapable to protect the people, to protect the business. Moreover, some of these measures and legal mechanisms were non-sanctional and untenable. But then, like a couple of months after, they started to do more wise. And if we talk about new COVID amendments, they are like, first of all, they did insolvency moratorium, which means temporary regime adopted by governments of Russia Federation, applicable to the most vulnerable business, according to the register, adopted by government. Commencement of insolvency suspended. No obligation to file petition in bankruptcy within the duration of moratorium. Some consequences of supervision come into force. Suspension of mortgage sales. Suspension of enforcement proceeding. Debtor has a right for installments provided that it falls within provided conditions. Second was rent payment decrease. which applicable to the most vulnerable business according to the register adopted by government, applicable retroactively, right to the substantially decrease rent payment, right to terminate rent agreement in case parties doesn't agree on rent decrease. Third one, force measure. The court may acknowledge COVID-19 pandemic as a force measure and thus relieve debtor from liability. However, debtor have to fulfill heavy burden of proof, like to the bankruptcy proceeding, and some other measures as taxes decrease or suspension, right to banking loan payment installments, right to loan for exchange to compensate salary. So if we'll try to summarize it, I would rather say that the state is trying to do something which could help companies to survive in this dire, strange, and very strange times. But the effect of such measures we would see not in a moment, unfortunately. That's why I maybe remain skeptical about this effort, because as we all know, the crisis is huge and now in latent stage. So I totally agree with Carol that we would expect a huge amount of business which will fall in bankruptcy. And we shouldn't be too optimistic about that. Thank you.
Thank you, Konstantin. So the measures that you mentioned, are those government mandatory measures? Are they something that people have to?
It's new legislation. So so-called
right.
new legislation which were undertaken in this like couple of months, maybe.
I see. Right. Thank you for that. It's very difficult. It's very challenging, and even though these measures seem to be they go a long way, at least on paper. You know, suspending things like rent agreements, mandating rent decreases. That's actually very much for the little guy. But it still is going to be difficult to put all that into place for so many people in hard times. So thank you. Now I'd like to turn to David. Now, the UK is having a lot on its hands, not to mention Brexit, but mentioning it, and it's got another lockdown. You are in lockdown, are you? Yeah, you'll have to unmute yourself, David. I think you're on mute.
There we are. Yes. 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 We're certainly in lockdown at the moment until.
Right. Yeah. It's almost also a challenging time as well. But I know that you might have something to tell us about a new corporate insolvency and governance bill. So this was something that was introduced as part of the response to the pandemic.
Yes, indeed. Yeah. Yes.
Right. And so hand it over to you.
Thank you very much indeed. Yes. So, well, good afternoon there in Hong Kong. It's morning here. I have to say is that Carol is the bravest of us because if she's in California, it's 1 a.m. So it's good morning to Carol. But actually, it's fantastic, isn't it? That here we can, through this technology, bring people together to talk about these subjects. The other thing I'd say is that it just shows the commonality, doesn't it? That here we are reacting to an event, the pandemic, a crisis, and we are all reacting to it in quite similar fashion, depending on files. And before I go on, I'd just like to thank Melissa and colleagues in the Law Society of Hong Kong for convening this event, which, as I say, is great and just shows our commonality. And I just, obviously we've had a spike in insolvencies since the first lockdown, which started in March 2020. So what is that, some 8 months ago. We've had some changes, as you've just mentioned. I just wanted to give a little bit of a background and some I don't know, cultural issues actually, is because it was only about, what was it, about 120 years ago, less than that, that we were locking people up for debt. I think in 1905, I see that we were locking about 12,000 people up for debt each year. Traditionally, until some changes in the 80s, and there's still this sort of perception about debt and guilt. Those, you know, if you owe people money and you can't afford to pay it, there's the degree of guilt that comes with that. We have over the past 40 years tried to steer our way away from that, and indeed followed much of the Chapter 11 precedent set in the United States, which to me at least seems much more debtor friendly. We have been traditionally creditor friendly, and I think that the Chapter 11 and then our own process changed that somewhat. So back in '86, and I was well into practice at that point, so I remember it well. We introduced administration. Then we had a battle between administration controlled by the debtor and receivership controlled by the creditor. That debate was sort of ended in about 2002. We had the Enterprise Act, which changed that dynamic, and it has led to a very common process that we have here, which is a pre-pack. Which is where you obtain protection from your creditors for a short period in order to put into effect a sale of the assets or of the business for the better benefit of the creditors, and that is all set up in what we call a pre-pack. Company voluntary arrangements, individual voluntary arrangements, all of these are introduced in the mid 80s, so that initially we started with Coronavirus Act 2020, which under which actually quite a few points have been made and quite a few changes have been introduced over the past few months, and that was a sort of all-encompassing. The government can do certain things in response to the crisis that we have. However, the Corporate Insolvency and Governance Act was moved alongside of that Coronavirus Act and introduced as a matter of urgency in order to protect businesses. I can quote a government minister who described its intention as this, is that otherwise viable companies will no longer face the threat of insolvency. The measures that the bill introduces will give businesses the vital support that they need to keep themselves afloat, thereby preserving jobs and maintaining productive capacity, enabling the foundations to be able for this country's economic recovery. And of course, this has gone on somewhat longer than we have. You've just talked about the second lockdown that we've had, national lockdown, and it's due to end in December. Even then, there's going to be quite considerable lockdowns on a regional basis, so that it is by no means the end. I think like Britain, United Kingdom, like the rest of the world is looking at the vaccine as the route to out of this unfortunate crisis. So there were temporary changes brought in by the Act, and they've since been extended, as I've talked about, And they introduced a moratorium. So it's not part of the insolvency process, but it's a rather broad measure available to all companies with some exceptions. It's quite important exceptions. Really what the thing is looking at is companies that are suffering as a result of the coronavirus. It's excluding others, but it's those that are suffering as a result of the coronavirus. And to obtain a moratorium, so it produces a moratorium, the directors of a company file a notice that they wish to obtain a moratorium, a statement saying in their view that the company will be able to pay its debts, a statement from an insolvency practitioner. We have, as you probably know, and I'm sure similar across the world, is professional insolvency practitioners, that they're willing to act as a monitor. And that in the monitor's view, it is likely the moratorium will result in the rescue of the company. And the moratorium comes into force on the filing of the documents at the court. So it's very much in the control of the debtor, subject to the oversight of the insolvency practitioner. So initial the moratoriums, 20 business days, and can be expended after 15 business days. And thereafter, it can be extended for a further 20 business days without creditor consent and without without any limit on it. We were a little concerned about this because it gives so much control to the company and gives little or no control to creditors. Quite like the administration process we have, but without those checks and balances. Where it's important is the role of the monitor. So the monitor is an officer of the court and is an insolvency practitioner. Creditors have no say in the selection, so this is done again by the debtor. And there is no provision allowing creditors to challenge the appointment. We were a bit concerned and wanted stricter controls over it. So that has been our immediate response, is this new procedure for a moratorium with a monitor. I should say that in addition to that, and some of these have been brought into effect by the Coronavirus Act, is in relation to commercial rent arrears. We had a suspension of possession proceedings and the ability to secure possession for commercial rent arrears in order to allow particularly retailers some protection. Companies' legislation has been changed to remove filing requirements, particularly audited accounts. Actually, there was also a rather nice sort of dynamic from the government, is that everyone should act very nicely. And indeed, bearing in mind the crisis, there's some sense to that actually, is because I mean, the point is that we all need some reflection of common decency, common understanding at this time of difficulties. So it's an important point. Just recently, just to show the government's position, is that the government made some changes in the law just recently to give back to the revenue, so HMR Revenue and Customs, HM Revenue and Customs, give back to the revenue some priorities that they had lost, and indeed, most importantly, putting them ahead of floating charges. And this is actually quite substantial, but it only applies to taxes that have been collected from others, so value-added tax or pay-as-you-earn tax. So this is money taken from others into the company and then kept there. Often, as I don't want to put it too widely, but the revenue can be the last to be paid. Is probably the biggest creditor in most insolvencies. But for items collected, we have this change.
Right.
So that's our immediate response to it.
Thank you so much. Thank you so much, David. That's actually quite a substantial number of measures that have been initiated, not only debtor in possession, but things like taxes and moratorium. It's all coming together in quite a huge package. So thank you for sharing that with us. Now we come to Phyllis. Scene in Hong Kong. Now we don't have debtor in possession. We're playing a bit of a catch up. So it's been resurrected, hasn't it? We're talking about it again. So it seems such an opportune time that you can tell us about what the updates are, how far we've got to. So over to you, Phyllis.
Thank you very much, Julianne, and thank you very much to the Law Society for asking us to present today on our new proposed legislation. Actually, I have prepared quite a detailed PowerPoint, which I'm very happy to share with the participants after the meeting, but perhaps I just won't use it for the purposes of the presentation because it's quite a lot of information. So I'll just go through the points, just see if we can cover most of it. So the Official Receiver's Office, together with the Financial Services and Treasury Bureau, are tasked with ensuring enactment of some new legislation in Hong Kong. And we aim to introduce a bill into the Legislative Council in January 2021, which is obviously very timely in the current environment. Because considering the role that Hong Kong plays as an international financial centre, it probably does come as quite a surprise to participants that we actually don't have any formal rescue legislation in place. As you know, Juliana, this is not for the want of trying. We have a report from the Law Reform Commission as far back as 1996 recommending corporate rescue legislation. And despite 2 previous attempts to introduce this legislation, we have been unsuccessful. And even now there is resistance from some stakeholders. We are a very creditor-friendly regime traditionally, and it's for this reason our current proposal is actually a very carefully crafted attempt to balance all stakeholder interests in a process which by its nature really requires compromise and collaboration. So the overall design of our new model is basically modelled on the Australian regime with a little bit of UK and some homegrown Hong Kong. So very much the jurisdictions that we normally look to in our legislative process. It will not be debtor in possession. It will be the appointment of an independent third-party provisional supervisor to oversee the process. It will be out of court insofar as possible to reduce costs, and it will be subject to a strict time frame to try and have a quick rescue of the company, recognising that really if the company can't be rescued within a short time, it's better to liquidate it for the sake of the economy. There will be a moratorium, which will provide breathing space for the provisional supervisor to formulate a proposal for creditors to vote on. And there will be very specific provisions introducing a phased payment arrangement to protect the interests of employees, to ensure that they will be paid at least what they would be entitled to in a liquidation situation very early on in the process. And if the rescue succeeds, they will actually be fully entitled to all their entitlements within 12 months from the date of any voluntary arrangement that's agreed by the final creditors meeting. Also, to encourage directors to act quickly to rescue the company, we will be introducing insolvent trading provisions in parallel. So the objectives of the new regime are to try and maximise the chances of the company continuing in existence insofar as it may be possible, and if not possible, at least to provide a better return for creditors than they would normally get in a liquidation situation. The regime can be used by Hong Kong incorporated companies or registered non-Hong Kong companies. There are excluded entities, most likely banks, insurance companies that have their own insolvency regimes in their own legislation. The process will be initiated by a resolution of members or the majority of directors of the company, or where the company has already entered the insolvency process by the provisional liquidator or the liquidator, so not by the creditors. The company must be insolvent or likely to become insolvent before the commencement, and before it can commence the process, the major secured creditors must be given notice of the intention to commence the rescue, and they're given 5 business days from the date of the notice to object to the rescue going ahead. Court leave is required for a registered non-Hong Kong company or where the company is already in liquidation. The provisional supervisor must be a certified practicing accountant or a solicitor with a practicing certificate in Hong Kong, and he will have to give prior written consent to appointment. The PS will be an agent of the company, and the powers of the directors will be suspended on the appointment of the provisional supervisor. The PS will assume control of the company and the company's property, and he will perform any function or power that the company or a director can perform. However, if the PS does consider it necessary or appropriate, the directors can be involved in the rescue process, so there is flexibility. On this point, I think it is interesting to note that a lot of countries with whom we normally align are moving towards debtor in possession US Chapter 11 type models. But in Hong Kong, this really is still not an option because there is still skepticism associated with leaving the management in control in a liquidation or in an insolvency situation. But our regime will be flexible enough for the provisional supervisor to engage the directors if he considers it appropriate. And the duty of the provisional supervisor will be to put together a rescue proposal as quickly as possible and put it before the first creditors meeting for voting. To ensure confidence of those dealing with the PS will be personally liable on contracts entered into or adopted in writing within 16 days. They can contract out of the liability and will be indemnified out of the assets of the company for these liabilities. The moratorium is the cornerstone of the process to give time to investigate and put together the rescue proposal. Certain matters will be excluded, including in criminal proceedings and certain employee claims, but generally there will be 45 business days on all enforcement proceedings, including enforcement of security. This can be extended by creditors in general meeting for up to 6 months, and it can be beyond 6 months extended by an application to the court. The regime for protecting our employees is very detailed and considered, and it will be a phased payment process involving 3 key stages. Phase 1 will ensure that all wage arrears will be paid on an insolvency will be paid within 30 days of the appointment. And this is really a very quick first payment for employees. The phase 2 payments will be made approximately 3 months from commencement, and the final phase will cover all employee entitlements, and that will be paid within 12 months of a successful voluntary arrangement. Any breach of the phased payment arrangement will free employees from the moratorium and they can take action. It was protection of the employees that has been a particularly difficult issue for us in Hong Kong. But ultimately it will be for the unsecured creditors to decide whether or not they want to accept the rescue proposal, and they control the approval process. The ultimate outcomes of the process will be to approve the proposed voluntary arrangement put together by the PS, or to reject it and wind the company up, or end the provisional supervision and allow the company to continue trading. The creditors will then be bound by the voluntary arrangement, and they won't be able to take any enforcement action in relation to any claim which has been compromised in the voluntary arrangement. Secured creditors are generally protected, and they can enforce their security after expiration of the moratorium or with the consent of the court at any time. So the new regime will be a much needed tool in the Hong Kong Rescue Toolkit. And we really have everything crossed that this time, this attempt to introduce this legislation will succeed. We will also, as I say, introduce insolvent trading provisions, but I don't have time to go into them today, but there is information about it in the presentation materials that I have provided. So very happy to take any questions. And again, thank you very much for your time.
Thank you so much, Phyllis. It seems as if we've got a very substantial legislation that we can look forward to. It's not something that it's immediate, but at least it's something that we should be finding it something that we can put through this time. It seems to be on the other end of the spectrum when you compare it with the UK legislation, where in the UK you put so much control and so much control in the hands of the debtor that the creditors are getting worried. And in our case, we actually want to hold on to control in terms of the creditor process, and we don't want the debtor to have so much control. So that's quite a contrast. Going on to some of the topics that maybe we can start to discuss in terms of just stepping outside of Hong Kong and looking at where you are now in the your local framework or your local legal regime, and what you're finding is a something that could have been, something more could have been done, or something that's not gone far enough. Maybe I could ask our panelists to just talk a little bit about your experience and how you think that the what newly enacted laws or laws to come are going to be as helpful as you would like them to be, you know, looking at your clients, looking at experiences around you. So I'm going to perhaps ask Konstantina, what's the situation when you look at what we have in Russia now? Do you think that people who are, you know, the middle, the small and medium enterprises, let's say, are they finding this very helpful? Is it really helping them to revive?
I'm not sure. I'm not sure that because so-called small business, they're not in a good position now, because from one point we have these economical issues, I mean, which all planet has, and from second angle, it's like the habit of states which trying to use, for instance, a criminal law as a mechanism in bankruptcy. And some creditor is trying to use the criminal law in bankruptcy. And, you know, it's like the main problem in Russia, which as a state, because, you know, Russia is trying to use criminal law to solve all problems. I don't know, from building a space industry to make a bankruptcy institute more effective. That's why I totally against that. You know, criminal law is a mechanism which is very exclusive, very unique, and it's not a common thing which should be used profusely, because it could ruin the human right, it could ruin the business, and it could literally explode the institute of bankruptcy. So the damage of using like criminal law in bankruptcy could be not like negligible. It will be huge. It would be glaring. So that's the problem now, unfortunately.
That can be very troubling. What about the U.S.? Carol, there's a successful case of restructuring. PG&E, we've heard a little bit about that, the electricity company, who seemed to come through it without too many scars. Tell us something about a kind of successful turnaround that made use of the system that you have and was able to come back.
Well, I think that it is ironic that this question follows Konstantin's comments on criminal law. PG&E did exit bankruptcy by the skin of its teeth. We could say that PG&E is one of the first the victims of climate change, because this is its second bankruptcy. The first one was in 2001. They got out in 2004. It was caused by drought, which eliminated their ability to generate power through water, and ended up costing the shareholders of PG&E and the state of California $45 billion. After 2004, PG&E had a history of not basically maintaining its equipment and letting things pretty much ride while paying what many think were excessive shareholder dividends. So PGE then rides into 2011 and essentially has a gas explosion that kills 12 people. That was the San Bruno gas explosion. And at that point, everybody, and I live in San Francisco, PG&E provides my electricity, but everybody that at that point was extremely concerned about PG&E. PG&E was tried in a criminal trial that resulted in it being found guilty of criminal negligence and many other things. And when they filed bankruptcy, they were subject to probation of the federal district court by Judge Alsop. So it was an interesting case from the get-go because they filed this time because of the number of fires in California that they had potential liability for in 2017, 2018. And Judge Alsop was right on their heels throughout the entire bankruptcy process about getting the company to, and these are my words, not to judges, but essentially clean up their act and pay attention to their aging equipment and the things that were causing trouble. So PG&E exited with $59 billion restructuring plan. The bulk of that plan was funding a trust to pay fire victims as their claims were decided. And PG&E exited on June 3rd, I think it was a Saturday on June 30th, actually the court entered the order. The reason it was so important is that California had set up a mechanism that was similar to insurance that would allow PG&E to finance some of its debt, some of its obligations, if they exited on or before June 30. So PG&E is now expected to request a rate neutral $7.5 billion securitization in order to finance the cost that it incurred in the bankruptcy. There's a lot that PG&E got right in the bankruptcy process, and they managed to keep Judge Alsop from increasing or making their probation conditions untenable. And shortly before exit, they were able to get more what they viewed as reasonable probation conditions. But the problem here is one that Constantine sort of hit the head on, is the management was terrible. The management had been terrible for a very long time. And PG&E is a company that is in many ways, we say in the US, one that was too big to fail because of the delivery of electric services or gas and electric to most of Northern California. So I'm not sure the PG&E story is over. They got through a restructuring, they were able to exit, but I think that they're still going to continue to be faced with climate change stress and maintenance and introduction of new equipment in terms of the transmission system. It's their transmission lines that are causing most of the problems. And in California, if your equipment fails and you cause a fire, you're liable. So PG&E's story is not over by a long shot, but it is, I think, a testament to Chapter 11 that they were able to corral the large number of fire victims they had from fires in 2017 and 2018, and to negotiate a trust that was subsequently funded by a combination of stock and cash to exit bankruptcy. And during the process, coming back sort of to the criminal part, and then I'll close this off. In that process, they were found guilty of 84 counts of manslaughter in connection with one of the fires. So we have, I think, an ongoing drama with PG&E. We pay the highest utility rates, or I should say some of the highest utility rates in the US, just because of, I would say, as a ratepayer, PG&E's bad management. PG&E has a new management team, a new board, and has a number of people that are supervising it directly, even though it has a board and operates independently. It's sort of independent with a significant amount of supervision and oversight, which was part of what it agreed to as it exited bankruptcy. And then, of course, it's still subject to Judge Alsop's probation orders because it's still convicted. It's fascinating. It's a fascinating case that you could have a convicted company actually make it through a Chapter 11 process and still be standing. So I think that's kind of the success, but I don't think the story's over.
So it's a successful story, but not a very pretty one.
That's exactly right.
David, just want to see if in the UK, you mentioned the legislation that's the measures that have been put in place. Have people been able to take advantage of these and being given breathing space to reconfigure the business and work their way through? You'll have to unmute, David.
There we go. Yeah, I mean, it's quite interesting talking about Hong Kong, Russia, and the States is the sort of spiritual change that we've had since the mid-80s, maybe late 70s, mid-80s, of giving some power to the debtor, overcoming that rather old tradition of debtor guilt, moving along that way. We then saw some changes in the early 2000s. Of course, we had a lot of insolvencies as the world crash, 2008, 2009. And that sort of legislation, the spirit has changed to give more power to the debtor as opposed to the creditor. There are still lots of protections a creditor has. The new bill that we have is a further move along that way. Now, it is the response to a crisis, and it remains to be seen whether we'll see a more permanent change towards pro-creditor. A lot of companies have taken advantage of it, particularly in the retail trade. But one can see is that there will be, I mean, we're likely to continue to have economic problems. Obviously, we've got Brexit now coming. We end the transition period at the end of the year. So we're going to have economic problems going on. And retail particularly has problems because the world is changing. And there are lots of challenges there to companies with the new technology, you know, that we're forced along with. So I think that it remains to be seen whether we will continue to have the pro-debtor legislation brought in by the new act, new statute early this year, and whether that marks a spiritual change for us going forward in that debate about creditor-debtor control of an insolvency process.
Thank you, David. And just to wrap up, I just want to ask Phyllis one thing about the local scene. Do you see the spiritual change in Hong Kong? You mentioned that we're very much creditor, we lean creditor so far. Is there any tendency or any trend you think at some point that we would be a little bit leaning away from the creditor, more towards debtor? What's your crystal ball?
I do think if we can get this legislation passed, it will be fantastic. It will be a foundation for rescue legislation in Hong Kong. I think the insolvency environment is changing, and the idea of failure being associated with fraud and bad management, that is now not always the case, as we see with the external features of COVID, the disruptive economies that we're seeing. You know, there is now just external environmental factors that really do give businesses a very difficult time to adapt and survive. So provided we can move away from that fault-orientated management taking the company into insolvency, if we can see it more as an environment to allow innovative businesses to continue or to grow in a different direction, I do think there's scope there. But I do think generally Hong Kong, we are still relatively conservative and we are still creditor driven. You know, that is our markets, that is our finance, that is our economies. So it will be quite a change. As I say, the legislation that we are proposing, there is the option for the provisional supervisor to engage the management where appropriate, but still very much the provisional supervisor will be in control of the process. So maybe, but not yet. And if we can get this foundation in place, then I think we might have room to build on that. So
so hoping to build on that. Thank you so much. And I just want to thank you all for being with us, sharing your very, very early morning and the best part of your working day with us, and also Constantine for sharing your birthday with us. So we're very happy to have you. Now this is this is usually where first of all, we hand over a souvenir, and secondly, we take a photo. I can't hand over a souvenir, but I can certainly take a photo. So this is what I'm going to do. So smile, and I'm going to try and take a photo of all of us. Okay? Okay. There, I'll send it back to you. So really happy to have you here, and I think that comes to the end of our session this afternoon. And I'm going to hand it over to our MC. Thank you, Corinne.
Thank you. Thank you once again to our session moderator, Ms. Gillian Dow, and our session speakers, Ms. Carol Daniston, Mr. Constantine Dabranen, Mr. David Green, and Ms. Phyllis McKenna. I'm sure for this insightful sharing, we have gained a much better appreciation of the topic. So now we have heard from eminent speakers from all over the world. I'm sure we all have some takeaways from all the sessions today. Today's webinar will soon come to an end. And may I now invite Mr. Fred Kan, Chairman of the Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, to share with us his closing remarks. Mr. Kan, please.
Ladies and gentlemen, this has been indeed a scintillating discussion on three important legal topics of concern to lawyers and non-lawyers alike in this era of COVID. On behalf of the Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, let me deeply thank our keynote speaker, our moderators, and our speakers. This is an unusual time. The pandemic has driven us to realize that the world must come together in the face of common calamity. Our problem goes beyond the pandemic. We must harness and equitably share life-enhancing scientific, medical, and technological innovations. We must find a way to go forward and get out of this pending world recession in the face of mounting unilateralism and protectionism. The heralding cry of Belt and Road Initiative of Connectivity must be the way forward. The signing on 15 November 2020 of the Regional Comprehensive Economic Partnership, RCEP, a free trade agreement between 15 Pan-Pacific nations, is a good sign. I'm optimistic. This webinar is a bridging event for the Law Society's third Belt and Road Law Conference to be held next year. We are actively planning for this big event with new forward-looking ideas. It will not only be a law conference for the Law Society of Hong Kong, but a conference for lawyers around the world. Therefore, please do not hesitate to let us have your ideas. Once again, let me thank our keynote speaker, our moderators, and our speakers, as well as all in the Law Society Secretariat and elsewhere who have helped to make this a success. I wish you all good luck, good health, all the best in the world, and please keep safe. Thank you.
Thank you, Mr. Kan. On behalf of the Law Society, we would like to say a big thank you to all of you who have joined us today. Hopefully, when the situation allows, we can meet you all in person again at our annual Belt and Road Conference in Hong Kong. Goodbye.